Welcome. This is the Demystifying Estate Planning live seminar, and we think we have an interesting program planned for you today. My goal is to make it informative and to give you kind of a general overview, primarily of the world of wills and trusts, a little bit on power of attorneys, and some of the things that you might want to think about as you continue your journey into learning about estate planning and kind of figure out what works best for your family. Just so you know what to expect, a little bit more about how the day is going to go, I want to run through the agenda with you very quickly. As I do all of my one-on-one private educational sessions, I start with a little bit of my background. I'm going to start with that here, just so that you have some context about where I came from, how I've gotten my education as a lawyer, my experience, because I assume that you're going to rely to some extent on the information I give you today, and you need an ability to gauge for yourself how reliable that information is. So I'm going to share a little bit about myself. When you come to my office and meet with me, I ask a lot of personal questions from the people that I visit with. And if it's a two-way exchange of information, it seems to make things go a little bit smoother. So that's the other reason I share a little bit of information. We're going to get through that really quickly and jump right into a general overview of wills and the basic will-based plan. Then we're going to kind of pivot and talk about trusts, which is a little bit more of a comprehensive planning tool. And we'll talk about powers of attorney, which should be part of any estate plan that you put together. After that, we're going to talk about Missouri's default plan, and you'll probably have some questions about what that is. In Missouri, as in most states, if you don't put your own estate planning in place, Missouri has an estate plan for you that will go into effect by default. And so I think it's important for you to know what that is. We'll have a 15-minute break, and then we're going to come back in and talk about some of the services you can expect around the act of estate planning. Many attorneys do it differently, and I think as you continue your journey into estate planning, it's important for you to be able to identify if you're dealing with an attorney that just does documents or just does documents plus comprehensive services around those documents. We'll talk a little bit about how you go about finding the best plan for you and your family, because there really are different ways of doing it, and we'd like you to know about the family wealth planning session way that we implement that we think gives you the most information that you need to make good choices. And then we'll spend just a few minutes at the end talking about what would be the next step. If you have completed your research and your education about estate planning and you're ready to maybe talk more one-on-one or to jump into estate planning, you'd like to know, I'm quite sure, what the next step would be. All right, so I'm just going to kind of go through and give you a little bit of information about my roots. I come from a blended family, meaning that in my 20s, late 20s, I guess, my mom and dad divorced and remarried, and that's my mom right there. That's my stepdad, my stepmom, and my dad. Fortunately, they're all still alive and well, and they live next door to each other in St. Louis, so it makes us happy when we go home to visit. Through their marriages, I've gained 4 lovely sisters, stepsisters. So this motley crew has a group of 7 daughters that try to take good care of them when they need it. Just quickly, hobbies, like most of you, I'm sure. I love to fish. I love to hike. During COVID, I needed a creative outlet, so I decided to keep my Christmas tree up all year, and I just changed the decorations. That happens to be a bridal tree. My son recently got married, but it's often a Valentine's Day tree or a St. Patrick's Day tree, and that's kept things entertaining around the house. My family, so this is not my roots family, this is my family that I had with my husband, Bob. He likes to brew beer and spirits, and I like to drink his beer and spirits, so we're a good team on that front. When he's not brewing, we like to travel. Up until recently, we traveled on a Harley quite a bit, but we made the decision that was getting a little bit too unsafe for us right now, so we traded that in for a little fishing boat. My youngest son, Jared, he's in college in Warrensburg, trying to become a paramedic firefighter type. And this is my son that just got married, Michael. He is almost 30, works at Pfizer, and this past Saturday, through him, I gained a beautiful daughter-in-law. That's Kara, his new wife. So that's a little bit about me. Just some of my educational background. I did grow up in St. Louis, lived there until I moved here to the lake in '96. Went to WashU. I pursued 3 degrees. I've got a degree in psychology, a degree in social work, and a degree in law. So that is kind of suggestive of the fact that I've had several different careers before I became a lawyer. Before I got my psychology degree, I was a musician, and I played keyboards around St. Louis in lots of different bands. Was not great at that, was never going to make a good living, so I went back to school and became a social worker. Did that for quite a few years in the St. Louis area, and that led me to my law degree. And then my first job as a lawyer was here at the lake, and I've done that since '96. Started out in Camdenton at a law firm, worked there for 16 years, became a shareholder or a partner after my first 2 years there. My partners were all considerably older than I was, so in 2014, I kind of saw the writing on the wall that I needed to transition into my own office as they transitioned into retirement. So I did that. And as an attorney, prior to starting my own office in 2014, I was a general practitioner, as were all of my partners. And in a small town, you really need to be kind of a go-to lawyer for all different kinds of issues. So I did the things that you see up on the wall there: criminal defense, adoption, personal injury, did a lot of estate planning and probate. And then when I started my office in 2014 in Osage Beach, continued being a general practitioner, but started peeling away some of those other practice areas until now we just accept estate planning clients. We don't do probate anymore. We have a few cases that we're closing out, but by and large, we're just an estate planning law firm now. You met Andrea and Melinda, and this is them in their work environments in our office. And we have a team of paralegals that help with the drafting and the proofreading of our documents. They're not here with me today. And along with Michael, we've got several other witnesses that come in and witness documents for us, and they're not here with us today either. Before we get into wills and trusts, I want to talk about just the concept of estate planning in general. And I thought, for me, maybe a good approach for jumping into this area was to talk about what comes to mind when I think of the phrase estate planning. And for me, and through my experience as an estate planning attorney, I see it very much as being a brick wall for people. And that's why I chose that image. You know, estate planning and legal documents and talking and thinking about our own mortality, those things can be rather daunting. And a lot of people find things that they would rather do than talk about those things. It kind of drums up issues of family dynamics and, you know, maybe your child that's not thriving the way you want them to thrive, or, you know, just all sorts of family issues. So that's bad enough. Then you add the complexity of the legal documents and just not knowing what direction to go with estate planning, how to get started, really. So I think of it as a brick wall. I hope to tear that brick wall down if any of you feel the same way. So by the time you leave here today, you've got a lot more clarity about the process. And I want to start by examining what an estate is. You all have one. I have one. It's everything you own in the context of estate planning. And your estate is everything you own, everything that you've acquired and worked so hard to build up and to protect for your family. It's what you own at the time that you pass away. All of that stuff is going to make up your estate. As we sit here today, and every days of our lives, there are assets that are in the forefront of our consciousness. We interact with them all the time. So when you go in to prepare your estate plan, you're going to know you need to have a plan to protect those items. Of course, it's going to be your home. That's an easy one. Your IRAs and 401ks. Jewelry, everyone knows they need to be able to give their jewelry to their granddaughter or whoever. Your vehicles, artwork, these are the easy things to plan for or to think about planning for. However, there are things that live sort of in the edge of our consciousness that we really don't think about very often, and we certainly don't think about them in the context of, planning for the transition of our assets. So I want to get the wheels turning and have you start examining in your own mind what things you need to be careful to look for and make sure you plan for them. For example, you might have a home or an interest in real estate in another state or another country that you need to be aware of and have a plan for to transition when you no longer need that item. I've met several clients here at the lake who have written children's books, and they might have a copyright on that child's book that someday could bring them a return, and they need to have a plan for transitioning that copyright or that trademark or that patent onto their loved ones. A lot of people have timeshares that they don't use. And this happened in my own family. My husband's grandfather had a timeshare, and when he died, it was the only thing that never made it into the trust and didn't have a plan for transitioning. And while he had a good trust in place, that single timeshare tied his estate up in court for 2.5 years. And there was that kind of a delay just to get everything wrapped up. A lot of people here at the lake live in condo associations or homeowners associations. And with that comes a beautiful community dock. And sometimes you're lucky enough to have your own dock slip that maybe you don't exactly own. You have, an indefinite right to use, but oftentimes those are provided to you under a lease agreement of some kind. And that's a dock slip that's good to pass along with your condo or with your home. So believe it or not, you got to make a separate plan for that rented dock slip with your estate plan. It doesn't just pull through on its own along with your condo. I have a lot of clients that have oil and gas and mineral rights in other states, Oklahoma, for example, that have been in the family for generations, and it just keeps getting passed down from one generation to the other. So if you have anything like that, just kind of be aware of that. Passwords, pictures, all those things, they don't have to have a monetary value to be worth transitioning to the next generation, but you certainly have to have a plan for getting them transitioned. Cryptocurrency, not many probably of us in this room have that in our portfolio yet, but it's becoming more popular. It's digital. You'll never hold it in your hand, and you may not think when you're doing an estate plan that if you have any money invested in that, you need to have a conversation with your attorney about protecting it during the transition. All right, so that's kind of the estate side of estate plan. Now let's talk about the plan side of the phrase estate plan. And it's as simple as the word is. It's just the way that we're going to transition our assets from us individually to the next person or entity. One of the things that makes estate planning so daunting is when you sit down to do your estate planning, you sit down to put a plan in place for something that's going to happen on a date, hopefully that's far, far, far in the future, that we cannot predict. We don't know what the tax laws are going to be at that time. We don't know who our family members are going to be at that time. We will have lost some and gained some. We won't know what the dynamics are. And we really won't know what our assets are because those change often throughout life. So the challenge is, how do you put a plan in place for all those unknown circumstances? Well, the answer is you do the best you can with what you know right now. You look closely and deeply at your family dynamics, at your assets, at the tax laws and all those things that go into picking the right plan for you. And you plan it on today's circumstances with maybe a slight prediction for the very near future. But the key there for your plan is that over time, as your life changes, as the laws change, so too should your estate plan. At least do a checkup and review to make sure that the plan you put in place today still works for you 20 years from now. We are going to start to talk about wills now. I view a will as being a very basic and important estate planning tool. You will learn that there's one more kind of plan that's a little bit less sophisticated, if you will, than a will that you put in place yourself, and that's the plan that the state has for you if you don't put a plan in place for yourself. But wills as an estate planning tool really do two things. Number one, it allows you to communicate in writing very clearly who you want to inherit your property when you pass. If you don't do that in the form of a will or another legal document, then the state's plan, which is written by statute, Missouri statute, dictates who gets your property. So it's very important at a minimum to at least take that control yourself and dictate who gets your property in a will. And you do that in conjunction with a couple other concepts like co-owning property or naming beneficiaries on your individual pieces of property. But just as a general rule, with a will, you can name who gets your property. Without a will, you can't, unless you use the beneficiary designations. The other thing that a will does is allows you to name the person who will take charge of your assets and make sure they get distributed. That's called a personal representative. We've all heard that term. Also, executor. Executor used to be more in vogue. Now it's more personal representative, but same thing. And the whole will is pretty much geared toward the judge. I mean, what you put in your will is directed toward telling the judge what you want to happen. And there are two myths that I'd like to debunk today, and if you walk away with nothing else, I would like you to walk away with a better understanding of these two issues. Number one is that if you have a will, you can avoid probate. And you can't. A will has to go through probate in order to be activated. Because essentially a judge is authorizing your personal representative to step into your shoes and to be able to sign all your titles and deeds and everything that you want to pass, authorizing this other person to sign all that for you. And nothing gets authorized without it going through court and the judge authorizing that. So I do want you to understand that if you have a will and nothing else, you are going to probate court. Wills are appealing to some people for two obvious reasons that I'm aware of. They tend to be less expensive than a trust-based plan, and that's partly because they tend to be very simple documents, relatively short documents, easy to prepare. Nowadays, a lot of people go online and download a simple will and get it executed. They're a little bit easier to interact with than trusts. So a lot of people like the simplicity of a will. So less expensive and easier to prepare. A couple things that you might want to consider, even though there's some benefits to having a will, there are some reasons why people, particularly our age, when you've kind of gotten to this stage in life, our lives tend to be a little bit more complicated. We tend to have a lot more assets, more valuable assets, and a lot of people that we might want to think about in leaving our estate. We've got young grandkids, we've got adult children, some of which may or may not be ready to handle an outright distribution. We might have special needs grandchildren. All of those, I don't want to call them complications, but all of those things add a level of complexity to your life that might be beyond the ability of a will to really handle in the way that you want it to be handled. We talked about how it has to go through probate court, and probate is kind of an interesting concept. What's happening is your will has to be filed, and it's essentially filing a lawsuit. You are filing a lawsuit against yourself, or someone on your behalf is filing this big production in court and paying for it with the money out of your estate. And you're doing that so that your creditors and your heirs get put on notice that money is getting ready to flow through your estate. And the benefit to creditors is it gets published in the newspaper, and they now know that if you owe them money, then they can try to make a claim for it in court during that time that your probate is open. And they actually get first bite at your assets before your heirs do. And the only other people they get paid as early as creditors do are the lawyers, the personal representatives, and the funeral homes. Really, your heirs are last in line to really get what's left over in a probate situation. Distributions, when it comes time to pay the money out that you've directed in your will, those distributions are outright, meaning in a basic will, you're not holding things back and saying, well, until my grandchild who's 6 is 25, I don't want him to really be able to get this lump sum. That's a situation that's better handled in a trust. A basic will doesn't have the ability to really make any kind of contingency plan. You die, it gets probated, those assets get paid out, no matter the age of the person or the situation of the person. So sometimes that's not real appealing, depending on your circumstances. Probate is expensive, and trusts are more expensive than wills, but they're less expensive than probate, typically. Depending on the size of your estate, if you have $15,000 in value of your estate, then probate is very quick and very cheap. If you have $40,000 gross value of asset, it's a little bit more expensive, but still kind of quick and kind of cheap. Once you get an estate that's more than $40,000 in gross value that's going to be moving through the probate court, things slow down considerably and they get considerably more expensive. The creditors are entitled to a 6-month period where you really can't move things forward. So your estate's going to be open for at least 6 months, and I'd say a year to a year and a half is more in line with what usually happens with your average estate. And this is a high estimate, but it's not uncommon for 5.5% to be the amount that is taken from your heirs and put into the pockets of the attorneys, the court system, the newspaper publications, all the costs that go into probating your will can total up to 5.5% of your gross estate. If your gross estate is $500,000, then you could be looking at about a $30,000 fee that goes out in fees to the various sources. If your estate is $1 million, then you could be looking at a $55,000 bill that doesn't go into the pockets of your loved ones. And I want to just make you aware of a couple different ways to think about the cost of a will versus a trust. Wills are a little bit more expensive than doing nothing, obviously. And they're a little bit cheaper than a trust-based plan. But I would like you to think in terms of, if I do a will, and that's relatively inexpensive now while I'm alive, what is the cost of that 5.5% or that 4.5% going to be against whatever size your estate is that is going to be going through probate? You can do a quick calculation and decide, if a trust costs this much, is it still considerably less than what it would cost for my estate to be taxed through probate? I wanted to kind of give you a visual of the probate process that we just talked about. And if this pipe is the probate court, your estate's going to come in one end and it's going to be subjected to attorney's fees, executor fees, appraisals, filing fees, creditors, claims, bond premiums, etc. And it's going to come out in a slow drip on the other side of the process. Like I said, anywhere from a minimum of 6 months to a year and a half on average. Okay, we're going to talk about a certain kind of trust called revocable living trust. There are a lot of different kinds of trusts out there for a lot of different reasons, but the trust we're going to talk about today is the one called revocable or revocable living trust, meaning you can amend it once you create it, you can revoke it, and you stay in total control of all of those assets that are in it. Like a will, a revocable living trust is a written document that explains how you want your property transferred and who you want it transferred to. But you're not writing it for the benefit of a judge, because in most cases a judge never has to see this document. This document remains very private and is never filed with the court. The only time it might be is if you have an heir or a beneficiary or someone that contests your trust and brings you into court. Otherwise, there's nothing that requires it to go to court. Like a will, you name the person that's going to step into your shoes and distribute your property. In a will, it's called a personal representative or an executor. In a trust, it's called a successor trustee. Trusts do avoid probate. They are, like I said, private documents that hopefully will never see the inside of a courtroom. They're very private in that, you can't look them up on CaseNet. They don't get published in the newspaper. And hopefully things will go smoothly, and only the successor trustee and the heirs that are entitled to assets under your trust will have to look at your trust. In a will situation, there are many, many people who touch that trust throughout the probate process. You've got the judges and the clerks and the newspaper publishers and, just all kinds of, paralegals and legal secretaries that all have to touch that will essentially and make it help it finalize the process. Whereas a trust, it's only going to be the people that your successor trustee has to engage to help them get through the process. That might be an accountant or a lawyer or an appraiser, property appraiser. So it's very private. I like to give a little history of trusts because, number one, I think it's kind of interesting, and it helps me understand the second myth that I hear a lot in estate planning that I'd like to debunk for you today, and that is that a trust is only for the extremely wealthy people. Trust did kind of start out that way, and I think that's why they now have the reputation for being only for the very wealthy, when in fact the role of trusts have changed quite a bit over the years. Back in the 1800s, trusts were a thing. We didn't have estate taxes, transfer on wealth taxes like we do today. We didn't have financial advisors that help us manage our assets. And really, trusts were used for the very wealthy back then to keep the money in the family and easily transition it to the next generation so that they could maintain their social class within the context of the trust. Over time, those circumstances changed, and we began to have tax laws develop on the transfer of extreme wealth, and trusts then began to be used as a tool to avoid some of those taxes. Still kind of a thing for the super wealthy. Then in the 80s, social circumstances changed and that really affected trusts, and that is we had an explosion of divorces. We had an explosion of personal injury cases and judgments and lawsuits, people getting sued. And we had just financial advisors that continued to kind of proliferate and help us manage the money without having to have it in the context of a trust to manage it. So trusts began to kind of leave the world of just for the wealthy and managing wealth and kind of get distributed around estate planners that helped the everyday person manage their wealth, didn't have to have a trust to do that. And trust began being viewed as something that helps protect you from creditors, lawsuits, sometimes estranged spouses, or if you lose your spouse and get remarried, trust can be a tool that helps your kids from maybe losing out on their inheritance if the new spouse kind of comes in and takes over. So the way trusts are incorporated into our society right now is they're really more of a tool that helps protect our assets, not so much manage our wealth. So it's very much useful to everybody. Trust can be a nice learning tool if you have a young person that's going to be inheriting wealth from you at some point, whether that's a child or a grandchild. If you're going to be keeping their assets in your trust for a period of time, you can begin to show them how to manage and prepare for their wealth by being a co-trustee of their own trust, or the sub-trust that lives within your trust for a period of time, so that there's a mature and seasoned trustee shoulder to shoulder with the young person that's coming up and getting ready to inherit. And over time, you can transition more and more responsibilities onto them to learn how to manage that inheritance. Trust can also be useful in that you can maintain what's called a lifetime asset protection trust within your trust. So if you have a child who's a special needs child on benefits, state benefits, you don't want them to inherit a big lump sum and disqualify them from that inheritance, then that money can live inside of your trust indefinitely and have, supplement that special need child's lifestyle without disqualifying them from their state benefits. And then when that child passes on, you can designate the assets to go then to another person outright. So those are handy if you've got not only just a special needs child, but maybe an adult child or grandchild that has a mental health problem or a substance abuse or a gambling problem, and you want them to benefit from your treasures, but you don't want them to ever have it outright. You need someone to be in charge of that, turn the valve on and off as their life circumstances wax and wane. So a little bit about the mechanics of a trust. We've talked about having a trust in place. The next thing that you need to think about is how you use it, how you get your assets into the trust. And I like to talk about that by analogizing it to a big red wagon. Let's say that the bucket of the wagon is the trust itself. You've put it in place, you've signed it, it's all tailor-made to your life circumstances. Now you need to get your assets in the trust, and you do that by retitling the asset from your name individually or as a married couple to the name of the trust. And when you do that, it magically gets into your red wagon. I recommend certain assets to be in your trust during your lifetime and certain other assets to go into your trust upon your death, but not live there during your lifetime. I think it's a good idea to have your house in the trust or any real estate that you own during your lifetime. Some of your, or most of your personal assets, your furnishings, your cattle, your pets, your tools, gun collections, artwork, all that stuff is really good to have in your trust during your lifetime. There's really no reason to have it live outside of your trust. There are other assets that are probably better suited to stay in your name individually while you're alive, and then to transfer on death to your trust. That would be things like your vehicles, motorcycles, boats, boat trailers, boat motors, things that you use and maybe buy and sell a little bit more often than you do your house. It can be kind of difficult to get a big long name of a trust on the back of a title. But more importantly, if you're in an accident, say in your vehicle, and it's owned by the trust and you've got to turn over documents, say the accident turns out to be your fault and you're getting sued, it's probably a better idea to not broadcast to the person who's suing you that you have a trust. Again, because of that old myth that where people think just because you have a trust, you must have a lot of money. I don't think you need to give them that information. You should make them work a little bit harder for it. So you've got your trust, you have funded your trust, and as long as you're alive and competent, you are in complete control of those assets still. It's not like somebody else owns them. It's like you still own them. You don't have to have anybody else's permission to buy and sell your assets. So I like to have you think of this person as being you. You've got a hold of your trust. That handle really represents the instructions in your trust. And as long as you've got a hold of the handle, you're guiding it around based on what the instructions in your trust are. If something happens to you, you pass away or you become incompetent, you're merely putting that handle down with all the instructions attached to your big red wagon, and someone else steps into your shoes, picks up that wagon, and is now in control, guiding them through the distribution process, and then finally depleting all of those assets. Someday they will all be dispersed, and the wagon can be disassembled. But there's nothing standing in between you and the person that comes in and takes over control for you, like there is in a will. We've got the judge and the probate process that kind of stands in between your will and your beneficiaries. In a trust situation, it's just, the next person in line steps up, takes control, and begins following your instructions. And just real quick, these are just a couple more visuals. This line represents your life, and above the line is when you're alive and managing your assets. This box here in the middle is representative of the trust. I like your trust to look like this. You've established your trust, you've got your house, your pets, all that stuff, your jewelry, instruments, tools in your trust, and then you've got your motor vehicles and so forth, your simple bank accounts living outside of your trust, remaining in your individual names with a transfer on death to your trust. And then over here, we've got some assets that are treated a little bit differently than the other two categories. We've got your life insurance policies, your retirement plans, your annuities. These always require a conversation with your lawyer about exactly how you should title them and how they should be treated, because there's a lot of factors that go into that. The biggest thing is we want to make sure that we're not creating more of a tax problem for you by putting it in the trust or having it flow through the trust. The reality is most of these things, retirement accounts and annuities, they should never be in your trust. Occasionally life insurance policies go in your trust, but usually what happens is upon your death, those benefits pay out either to your spouse or to the trust. But those things are very tax sensitive, so require a good conversation with your accountant and your lawyer. This is an idea of what it looks like when your assets actually get distributed. So the first step is upon your death, all these things you had transfer on death to, they're going to flow down and get reunited with the assets that you had in your trust. And then any assets that are going to pay out of your life insurance, your retirement plans, your annuities, they could all conceivably end up in this temporary holding place where everything is either liquidated, distributed, liquidated and turned into cash, or maybe you're going to make in-kind distributions, or your successor trustee is, meaning they're going to give the sofa to Molly and they're going to give the house to Betty. It just depends on what your instructions are. And really, I wanted to just have you think about your family structure. If you are leaving assets to the younger people, then you just want to think through, is this someone that really is ready to prepared to have an inheritance from me at any given time? Are they old enough, above 18? Are they mature enough? Well, it might be 20, 25, 30 years old before some people are really mature enough to receive a big lump sum distribution. With a trust, you can hold it in trust, you can distribute it over time, a third now, a third when you're 25, a third when you're 30. There's really just endless possibilities there. Once it's in this, all your assets are in this holding place, then that's where the distributions are made. And for example, you can instruct your trustee to give a third to charity and then a third to each of your 2 children, for example. Or you might skip your children entirely. It might be that your children are established and have plenty of money, and maybe you're creating more of a tax problem for them by leaving them your money, and maybe it would be more helpful to go straight to the grandkids. So you can do that with a trust. You can skip over your kids and go straight to the grandkids. Or maybe you want to keep your assets in your trust for the lifetime of your children, protect that money from your children's creditors, or estranged spouses, or themselves. Like I said, if they've got a substance abuse problem, allow them to benefit from the assets when they need something, but by and large keep everything there to then go to your children after to your grandchildren after your children pass away. I'd like to talk for a minute about the powers of attorney documents that should accompany any robust estate plan that you put in place. Any will, any trust plan should always be accompanied by powers of attorney. And in fact, if you choose not to do a trust or a will and just to allow the Missouri default plan to be your plan, you should still have powers of attorney, because the Missouri default plan does not address incompetence issues. It only addresses issues from passing away. We'll talk first about the general durable power of attorney. Now, the word durable simply means you put it in place when you're competent, and if you become incompetent, that document doesn't lose its authority. That's what the durable means. If you become incompetent, it doesn't evaporate, if you will. And you always want it to be durable. I can't think of a single reason why you wouldn't. I mean, that's exactly the reason why you put it in place generally, is to protect against your incompetency. I suppose you might want to do it if you need to authorize someone. Mike probably sees this in the mortgage world. You might need to authorize someone to sign legal documents for you, so you might put one in place for that reason. But in the estate planning world, we always want your power of attorney to be durable. The power of attorney for finances and the power of attorney for healthcare really should be two separate documents, because they cover completely different sets of circumstances. In the olden days, meaning even as recently as 10 years ago, you would often see these documents combined into one, and that gets kind of cumbersome. There's not a lot of good reasons to do that. It's better to keep it clean and keep them separated, because you don't really want to have to go to your bank and hand them your power of attorney and, show them what your plan is for your health care. You want to just keep that separate. Powers of attorney are documents that allow you to say who steps into your shoes to make decisions for you over your financial life when you're no longer able to do that. And that person that you name is called an agent or an attorney in fact. I don't like to use that term because people confuse it easily and understandably with attorney at law, which is what I am. And I don't want them thinking that by naming a power of an attorney in fact that they're naming me to manage all of their financial assets. That's not the case at all. So I like to use the word agent. And I also like to have my powers of attorney effective immediately for a spouse, because you're kind of commingling all of your financial life anyway. Make it immediately effective for your spouse. But anybody other than your spouse or your significant life partner, their powers are only going to be effective either upon your incompetence and your spouse can't do it for you anymore, or if you specifically authorize them to be activated for some reason. But in my experience, there's usually not a lot of reasons why you want anybody other than yourself and your spouse authorized to make your financial decisions for you, unless it's on a very temporary basis. Let's talk about power of attorney for health care. Again, the person that you put in place to make decisions for you is usually called an agent, a healthcare agent. These documents are not effective when you're able to make your own healthcare decisions. They only get activated upon incompetence, and it usually requires a doctor to make that decision, although you can choose in the language of your document to say that that decision gets made in some other way, maybe a panel of people or your spouse. I mean, I'm most comfortable naming the doctor because they usually have a better set of tools to determine if you're incompetent. Some people don't want it to go through the doctor and would rather have a rule that applies to or is applied by a loved one or a couple of family members. Healthcare durable powers of attorney really became in our consciousness as a society back in the 90s, and I think it's safe to say that all of us are old enough to remember the Terri Schiavo case. Does anyone remember? It's a really sad set of facts. Terri Schiavo was a young lady, 26 years old, when she suffered a terrible heart attack at 26. It deprived her brain from oxygen, and as a result, she went into a coma, and she became in a vegetative state. So she had two things going on. Terri was married and had a husband that loved her very much, and she was young enough that really her parents were still very involved in her life and loved her very much. And when she had this horrible event happen without a healthcare directive in place, her husband and her mom and dad had a very different opinion about what should happen to her. Should she stay on life support indefinitely, or should the life support be withdrawn and she be allowed to allow the natural course of dying to happen? They ended up fighting over that decision for 15 years. And during that time, she was removed from life support and put back on life support, a total of put back on 3 times, removed twice, I guess. And it wasn't until the U.S. Supreme Court, they fought it out in court because that was the only way they had to make a final decision. And the hospital needed to know that what they were doing was the right thing to do, and the court had to say it. But the U.S. Supreme Court decided to not hear the final appeal, and so the court, right before the Supreme Court, their decision stood, and it was the husband's request that life support be removed. So it was, and by that time she had emerged from the coma, and so she had some eye contact, some eye blinking going on, but still no brain activity, but she had some things going on in her body that made it seem like she was interacting with the rest of the world. So really made it a hard and horrible choice, but ultimately the life support was withdrawn and she was allowed, and I think in her case it was more of a feeding tube issue than anything. It was removed and she was allowed to die naturally at that point. Had Terri had the opportunity to have a written healthcare durable power of attorney in place before that horrible day, then it would have spelled out who had the authority to decide life support or no life support. Would it be the husband or would it be the parent? And they could have avoided that 15-year struggle. I want to spend a little bit of time talking about the default plan, the Missouri default plan, because I think it's important for you to know what that plan looks like. I suspect some of us in this room probably are relying on that default plan right now, maybe with a couple of beneficiary designations, the transfer on death designations on a few things. We might co-own property with a spouse or with someone else, but by and large, if you don't have a will or a trust together, then this is going to be your plan, at least for now. It is a plan that's written in statute, and 1996 was the last time the statute was revised. It gets updated every now and then. But it says, in terms of who gets your property, I'm going to have, we're going to talk about this person here in green. If this person, let's say his name is Joe, he dies without a will, without a trust, so he's relying on the default plan. He's not married, so the next couple scenarios, we're talking about someone who is single. If he has children, the Missouri default plan says everything goes to his children. Now, these are his adopted or biological children, not stepchildren. If he had children that have since passed away but left him some grandkids or some great-grandkids, the statute says you just keep going down the line, starting with the children, until you find somebody alive in that generation, and then they get it. Or if there's multiples, then they get it divided equally among them. If he never had children when he died, but Joe's parents were alive, then Joe's parents would take his full estate, along with his brothers and sisters. So mom, dad, brother, sister would all share in equal parts. If they were deceased, but he had descendants from his brothers and sisters and his parents, then they would take. And it just keeps going up the line. If there are no parents or brothers and sisters, but he's got a grandparent or an uncle, they would take. And if there are none of them, then the great-grandparents, great-uncles, and first cousins, once removed, would take. And all the way up to the great-great-grandparents, great-grand-uncles, and so forth. So that's pretty far-fetched, but it does happen. Now, scenario, if you die under the Missouri's plan and you're married, this is how your estate would be divided up. If you have no children, but you have a spouse, then the spouse gets 100%. That makes sense. If you're married and you have children and your spouse survives you and your children are only with the spouse that you presently have, you don't have any children from a prior relationship or a prior marriage, then your spouse gets the first $20,000 and then half of your assets, and then your children divide the other half equally among them. If you're married, your spouse survives you, and you have children with your spouse, but let's say you have at least one child with somebody other than your spouse, then that changes things considerably. Now your spouse takes half of your assets, and your child with the previous relationship and any children that you share with your spouse, they all take the other half of your estate and share it equally. You know, just a little food for thought. Kind of think about whether any of those scenarios, if they fit you and if that is okay with you, then it's good for you to know that that's the plan that would be in place. If it's not okay with you, then it's a good idea to look at putting your own plan in place. All right, so I want to kind of move away from the documents themselves for the next several minutes and talk about the kinds of services that you might look for when you're having the documents prepared and beyond. Because sometimes the services that you get with the documents are as important to making your plan work when you need it to work as the documents themselves are. And I really break this into two categories. I like to talk about it in terms of a documents-only estate plan and a documents plus comprehensive services estate plan. And sometimes I call that a curated estate plan model. So really these are two different service models. You will see attorneys in this area and beyond, I think, really come out more in the camp of documents only. It certainly has been the common practice throughout the United States to have more of a documents-only approach. And that's where, you go in, you see the lawyer, they tell you what you need, they put it in place, you sign the documents, you walk out the door with a set of instructions on now how you make the documents work for you. You fund the trust or add your beneficiary designations without really a whole lot of input or support from the attorney or the attorney's office to making sure those things happen. And some people are very good at getting those things done, but most of us need a little bit of support as you go through that arduous process of getting all of your assets into the trust, for example. You just need some help making sure it happens, because if it doesn't happen, it's catastrophic failure at the end when it's too late to do anything about it. I want to kind of highlight that, that situation with a little story that happened to a friend of mine named Allie and her family that utilized the documents-only approach. And I don't think they knew that was happening. And I think you could be in that same situation. I want you to be able to distinguish when you're talking to a lawyer about estate planning. Am I going to just get a set of legal documents, or am I going to get documents and support to make sure they're fully funded and I'm fully supported in getting through the entire process, and so that the estate works for me when I need it to. So my friend Allie, she's a lawyer about my age, and when she was in law school, she was married to her husband, and her husband's dad, so her stepfather, decided it was time and necessary to get an estate plan in place for himself. He had been married several times and was getting married a third time, I think it was. And he went to an attorney and selected a trust-based plan for himself and his family, paid the lawyer $3,000 to put the trust together. This is several years ago. And felt pretty good about himself, thinking he had everything in order so that if he passed away, his main objective was he wanted all of his estate to go to his kids. If his things with his wife or wife-to-be didn't work out, he didn't want the wife to end up with everything or really anything at that point. I think she had her own estate that provided for her. So his main objective was to make sure everything went to the kids without any problems. While she was in law school, he actually did pass away, and because they knew he had a trust, they thought everything was taken care of. But to their surprise, after he passed, they found out that nothing had been funded into his trust, and everything passed through the probate court, and in fact ended up bringing the family into two courts, one in Florida where he lived and had a house, and one in Iowa, where he also owned real estate. He had to have probate cases in both of those states, and the estranged wife was now able to begin making some claims for some of that property. So she was able to get the family into yet a third lawsuit. The family was mortified. Number one, they're wanting to grieve the loss and not fight 3 lawsuits, yet here they were after he had tried to do the right thing and get a good, solid trust in place and funded. Allie, being the law student that she was, thought for sure that this would be considered malpractice, that an attorney that could take $3,000, put in a trust, and then the family end up in 3 courts had to be malpractice. And as she graduated law school and became an attorney and talked to a lot of different estate planning attorneys, and she herself became an estate planning attorney, what she found was that this was really common practice. It wasn't malpractice at all. Attorneys don't learn good service practices around getting estates in place. It's certainly easier for us just to give you a set of documents and a set of instructions and cover ourselves with paper and document that we told you to do it. If you don't do it, then it's not on us. When in fact, that's really not giving you the most important thing that you're purchasing from us, and that is implementing the plan that we prepare for you. So I want to change the circumstances a little bit and tell you Allie's story just a little bit different if her father-in-law had gone to a documents plus comprehensive services attorney. He knew that, let's say he knew he was getting married and he was going to do a prenuptial agreement so that if it didn't work out, his third wife couldn't make claims to the inheritance that he wanted his kids to get. So he did a prenuptial agreement and he did a trust with a comprehensive or a curated estate plan attorney. And when he went into that attorney's office, the attorney just didn't sit there and tell him what he needed. The attorney sat for 2 hours and explored with him first what his life circumstances were. What are your dynamics? Do all your kids get along? Do you have a blended family? And so now you've got 2 bloodlines that you want to make sure share equally in the wealth. Or maybe you want to make sure only your bloodline shares and your spouse keeps their inheritance in their bloodline. What kind of assets do you own? Do you have real estate in other states? Do you have any of those edge assets that we talked about earlier that we really need to put a plan in place? Kind of look at what the tax laws are in place and the value of your assets to see if you've got any tax problems that now we need to plan around. It takes a good hour to 2 hours to really get into all of those important details so that as an attorney, I can know what plan will help you the most, and you will know enough about the law that you can tell me what plan you think would work best for your family. So together, I support you to make the choice, a will, a trust, or no plan at all, and I give you a flat fee, and I tell you what that plan and all those supporting or ancillary documents will cost, so there's never any surprises. You sign an engagement letter, and we right away go into drafting that trust plan in ways that are tailor-made to you. If you've got a special needs child, we've got a provision in there that plans for them. If you've got grandchildren that are 3, but you want to make sure if their mom or dad dies first, that their assets live inside your trust until they're 25 when they get half, and then 30 they get the other half. We really go into a lot of detail drafting the specifics. And we take all of the assets that you own and we list them on an asset inventory that during our time together becomes a checklist and a guide for you so that we know exactly what assets go into the trust, exactly what assets are going to go to specific people, and exactly what assets you want to keep in your name until you die and then transfer them into your trust at that time. And we make sure all your edge assets are listed on there. After you have your trust in place, we put that asset inventory in your portfolio, and you can see a sample of what that looks like on the table back there. And what that becomes is then a treasure map to your loved ones, so that when they get your legal documents, they're also getting this map of where all your assets are, what you have, what they're worth, what the policy numbers are, and where they can find them. And that way they're not having to spend the first 3 months after your death watching your mail to see what statements come in the mail. They're not having to get your tax returns or tax transcripts for clues as to what you owned. I don't know about your family, but my family and a lot of families, we don't have a lot of conversations with our parents about what we own or with our children about what we own. And so it really is a mystery that has to be unfolded unless you have this asset inventory. So they've got that. The other thing that we like to do as a part of a comprehensive service is when you come in to pick up your estate planning documents after you've signed them, we invite you to sit for a video called a legacy interview. And it's a way to begin putting little short videos, maybe a little video library on a thumb drive, where you're telling a family story or explaining a value or a tradition that you think is important for your grandkids to hear, or maybe you're explaining why you made the estate planning decisions that you did on the video. Maybe you're fairly certain people aren't going to be too happy with your choices and you want to eliminate or reduce the fighting. So you've kind of put it on a video for your family to be surprised with when they take possession of your legal documents. So I think that's part of an important comprehensive estate plan. Then after your plan is in place, it's important. Your life is going to continue to change unless you pass away the next day, and hopefully that doesn't happen to any of you. Your life is going to continue to change. The tax laws are going to change. You're going to buy and sell things. Your family, you're going to have new babies in the family. You're going to lose people. So really, at a minimum, every 3 years, you should be reviewing your estate plan to make sure that all those details that you wrote down in that moment that you did the planning are keeping up with the evolution of your life. And if they don't, you need to have access to your lawyer, a quick phone call or a quick email, just say, hey, this is where we're at. These were the choices that worked 3 years ago. Do I need to make any updates right now? I think that is extremely critical. The concept that you're reviewing your estate plan at least every 3 years, and you're updating your asset inventory every time you buy a significant asset or get rid of one. That way you know your plan is going to succeed when you need it to work for you, and you know your family's going to be well taken care of at that time. You also get the benefit of having an attorney or a law office that you know your family can turn to in their time of need. If something happens to you and they've got questions about how to administer the trust, we're just a phone call away. So I think there's a lot of benefits to the comprehensive estate plan approach, and that's certainly the one that we employ at our office. If you are in a situation where your family has lost a loved one and they really don't know what they owned because there is no asset inventory and there weren't a lot of conversations about that, the state has a Department of Unclaimed Property. Perhaps most of you are familiar with that, but in case you're not, it lives at in Jeff City, and the treasurer is responsible for taking possession of assets that are lost and never claimed. And a lot of them come from banking institutions and safe deposit boxes. Certainly not all of them are a result of estate planning failures, but certainly a lot of them are. And Missouri alone has $1 billion in unclaimed assets right now. 1 in 10 Missourians actually have unclaimed property sitting there. It's probably not a lot, but it's something. Each year, organizations and banks and so forth turn over another $1 million to this office because it hasn't been claimed. So another reason to have a nice, thorough asset inventory. If Allie's father-in-law were to come to us for estate planning services, we would have started with a family wealth planning session. And that's just the name that we assigned to that first 2 hours that we sit down and continue this conversation of education. In fact, what we're having here today is very similar to how I start out my family wealth planning sessions, except the big difference, so I'm giving you information. The big difference is I also spend a lot of time getting information from you. Again, you know, we talk about your dirty laundry. We talk about dynamics that might interfere or bubble up to the surface after you're gone. A lot of times, probate court is as difficult as family law court. A lot of emotions, as you can imagine, surround death and money, and that's what probate court takes care of. So we spend a lot of time doing that. We'll sit and make sure you understand all the different estate plans, help you pick the one that fits your family the most, or if you decide one doesn't fit you just want to go with what you have, then you at least have the peace of mind that that's the best decision for yourself. We engage services, we decide on the flat fee, and then you're good to go. We begin drafting the trust, and then you're in that pipeline. We've got a 3-meeting established process. So the first meeting is the family wealth planning session, and then from there we do a little bit of a review of your documents to make sure they're ready for you to sign, and you come in and sign. And we've got that witness pool there and a notary there. Melinda handles those signings. And then you come back about a month later and actually pick up your documents. And by then we've made you a copy on a thumb drive of signed documents. So if you want to send a copy to your decision makers or your heirs, you can certainly do that. If you've sat for your video, we've got that on the thumb drive. And then we talk to you about what kind of maintenance plan you want. If you want the 3-year free maintenance plan, we get you on that. If you anticipate a more rapid rate of change in your life, for whatever reason, you're retiring, you're moving, you're buying a new home, you're having a bunch of grandbabies, then we talk about maybe getting you in for a more frequent review, an annual review. And for that, we've got a small membership fee that allows you to get that more frequent review and then some discounts on any updates that you might have to do. Our estate plans range anywhere from, the will-based plan ranges from $2,500 to $3,500. On average for a single person, it's $25,000. For a married couple, on average, it's $3,500. Your specific circumstances might fudge that in one direction or the other, but that's a good average. And then our trust-based plans, they range from a flat fee of $3,500 up to $7,500. $7,500 being the one with the most bells and whistles you can possibly have. In my experience, most single people fall into a $3,500 to $4,500 category, and for the average married couple, it's $4,500 and sometimes closer to $5,500. But I wanted you to have an idea of what at least we charge at a comprehensive estate planning law firm. And for anyone who thinks that they are approaching the conclusion of their educational journey for estate planning, and they're ready to take another step toward actually doing their estate planning, then the next step is usually scheduling the family wealth planning session and getting a little bit more education about the plans and selecting a plan and then going from there. If you want to do a little bit of if you're ready to schedule a planning session today, we like to incentivize you to actually move in that direction because we know this is one of those things that we've all put off for years. And if I can help you get that done sooner rather than later. I like to try to help you do that. And if you make a planning session appointment today, we'll give you a $250 off coupon as long as you get your planning lined up by the end of March. And that $250 coupon would be toward the cost of a will-based or a trust-based plan. Well, I'm glad you joined us online for this video educational seminar on demystifying estate planning. If you have any questions after you watch this video, certainly feel free to call our office or contact us through the website, and we'd be very interested in helping you get those questions answered.